You're doing a great job.
Hey, thanks. All right.
Your Honor, may counsel briefly,
Nothing like fishing for compliments. Go
Okay.
ahead.
may counsel briefly approach?
You may.
Ashley Lonnie for the people.
And good morning, Your Honor. Sydney Rushing, an opinion on behalf of Mr. Warren, who's approaching my right. Please state your name for the record.
Anthony Warren.
Thank you. Your Honor, at this time, we'd like to set this matter for a preliminary examination. The video discovery that was outstanding has been tendered, so discovery is complete.
People have their witnesses available the 18th.
Well, we will try, Your Honor. Thank you.
Preliminary examination in person, March 18th, 2025, 9 a.m. before Judge Moore. Bound continued.
Thank you so much, Your Honor. Have a great day, Judge.
You do the same. Court calls case People versus Bianca Rowell.
Good morning, Your Honor. Chief Assistant Prosecutor Victoria Burton Harris appearing on behalf of the people.
Padilla on behalf of, excuse me, Ms. Bianca Rowell. Ms. Rowell, please introduce yourself to the court.
Hi, my name is Bianca Rowe.
Thank you.
Your Honor, days and times at the probable cause conference. We do need a little time to sort of gather some evidence and some documents, to talk to the people about a resolution. We're asking for a 3-week adjournment.
March 27th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Court calls case People versus Anthony Taylor.
Good morning, Your Honor. Can I do behalf of the people?
James Feitfeldsky appearing with and on behalf of Mr. Taylor, who is approaching. State your name, please, for the judge.
Anthony Taylor, Your Honor.
Thank you. Your Honor, this is a first PCC. We are asking for a 2-week adjournment for further discovery and investigation in this matter.
Probable cause conference adjourned March 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. I'll be done. Okay, take care.
Thank you, Your Honor.
Thank you. Court calls case People versus Laura Andia.
Ashley Lonnie for the people.
Assistant Public Defender Chinazi Kiriakimerly, Your Honor, on behalf of Miss Laura Andia, who is approaching.
Miss Andrea, could you state your name for the record, please? Laura India.
Your Honor, we are asking for an adjournment in this matter. We had not had an opportunity to speak with Miss Andia previously, but we suspect that there may be some Padilla issues that we need to.
I don't.
To the actual approach.
Probable cause conference will be adjourned April 3rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Teresa Johnson.
Assistant Public Defender Jay Bellinger on behalf of Ms. Johnson, who approaches. Johnson, can you please state your name for the record?
No name Johnson.
Hello. All right. I have 3 plea forms. Is that going or?
That is correct, Your Honor. I have advice of rights right here. My understanding is my client's going to be pleading no contest, Your Honor. Those police reports were sent to the court.
Yes, and I reviewed those. And so starting in the case ending in 0779, the plea form indicates that the defendant will be pleading no contest to added counts 3 and 4. 3 being an attempted resisting and obstructing, 4 being an assault and battery. The first one being a 1-year offense, the other being a 93-day offense. In the case ending in 5152, plea form indicates the defendant will be pleading no contest to the charge of attempted resisting and obstructing the 1-year offense, as well as the stated count 2 of assault and battery, the 93-day offense, and count 1 would be dismissed. There's also a global agreement to 2 years probation with assessments, treatment, full restitution on all counts, even the dismissed counts. I would indicate as to the probation, I don't see that there would be an issue, but I can't bind the sentencing judges in these cases to that, but I don't see that there necessarily would be an issue regarding that. In the case ending in 5189, defendant would be pleading to the stated count 2 of assault and battery, the 93-day offense, count 3, the attempted resisting and obstructing the 1-year offense, and count 1 would be dismissed along with that same global agreement. In essence, just a short of it, because there's 3 cases, Ms. Johnson, you would be pleading to 3 charges of assault and battery and 3 charges of attempted resisting and obstructing. That's the court's full understanding of the agreement.
That is our understanding as well, Your Honor.
Yes, sir.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
State your name.
Teresa Johnson.
Okay. Ma'am, it is a court's understanding that you're going to be pleading no contest to 6 charges. Is that your understanding?
Yes, sir, it is.
3 counts of assault and battery, those are punishable by up to 93 days in jail, up to a $500 fine plus court costs. You understand that?
Yes, sir, I do.
Also, 3 counts of attempted resisting and obstructing, those are misdemeanors punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. And you understand what a no contest plea is?
Not guilty?
No, we discussed what a no contest plea
Mhm.
means.
Say it again.
The no contest plea means.
You may want,
Thank you. The no contest.
now it's hard when it's your first time in the courtroom.
But that the court will take it as a guilty plea, but you don't have to say anything that you did wrong. The court's going to use the police report to form a factual basis, okay?
Okay.
All right.
Okay.
Thank you, Your Honor.
Yes, made it clear.
All right. So you have a clarification now as to what a no contest plea is?
Yes, sir, I do.
All right. Tell me what you think you're doing with a no contest plea.
I don't have to plead guilty, but the court will take it as a guilty plea, but I don't have to say anything that I did right or wrong or,
And
what
the court's going to use the police
the court's
report
gonna use the police report.
to establish
against
a
me.
factual basis.
And I'm going to assume that the information contained in that police report is true, or certainly that you're not contesting those facts.
Okay,
Understand that?
yes, sir.
Okay. Do you have any questions regarding that part of?
You said, well, regarding that part, no, but you said you haven't found a sentencing, Your Honor, yet?
Pardon?
A sentencing judge yet? You haven't found one?
No. These cases I would be taking, okay. That's
Okay,
the important part for you to understand. So I need you to understand this about a no contest plea. Let's go back to,
okay,
and hopefully when I get through things, it will all answer for you. But
thank you.
the no contest plea means that you're no longer wanting or desirous to contest these 6 charges. You understand that?
Yes, can you
Alright.
repeat what the 6 charges are again, please? Now, you don't have to go in depth about it, just
that's
give me the
okay.
title.
That's okay. If you don't hear something or understand it, I have to make sure that you do.
Okay, thank you now.
There are 3 charges of assault and battery.
Yes, sir.
Misdemeanors punishable by up to 93 days in jail, $500 fine plus court costs.
Okay,
Okay?
yes,
There are 3 charges of attempted resisting and obstructing a police officer, or yes, attempted resisting and obstructing a police officer.
sorry.
Those are misdemeanors punishable by up to 1 year incarceration
Okay,
and a $1,000 fine plus court costs.
okay,
Okay?
yes.
It's the court's understanding you're pleading no contest to those charges.
Okay, so if I wanted to pay them off, I couldn't do that either? Can I?
Wanted to pay.
Pay
them
the,
off.
like, $1,000 for the resisting and
Okay,
obstructing a police
so-
officer?
All right.
No, okay.
That's the maximum fine.
Okay,
Okay, that's not a dollar amount that you could pay and just be done.
okay,
Okay, you understand that?
I believe so.
Well, I have to make sure that you understand.
Yes,
Ms. Johnson, listen, if you're not understanding,
no,
then I'm not going to take your plea.
I
So,
understand.
no, just listen.
Okay.
And it's not, I'm not mad at you about that. or
Okay.
anything, Okay?
Yes, sir.
I have to make sure that you understand what you're doing. And not all of a sudden end up in a circumstance where
Yeah,
you didn't understand why you did something or whatever.
okay,
The other part of, just so that you know, a no contest plea is that for the purposes of sentencing, the respective courts are going to treat you the same as though you had pled guilty to these charges. You
okay.
understand that part?
Yes, sir.
Okay. Now, you understand also that, I almost hate saying it, but I'm going to say it. There's an agreement between counsel that you'll be placed on probation. But because I'm not the sentencing judge in these cases.
Okay, I wish you were.
Huh?
I wish you were.
I don't get that a lot. Thank you.
You're welcome.
But because I'm not the sentencing judge,
Okay,
I can't bind the sentencing judges to this agreement.
okay,
So that while that's an agreement, and from my perspective and experience, I don't see that there'd be a problem with it. They may decide something different.
okay.
You understand that?
Yes, you're not the sentencing judge, but can't make the decision based off what they might say, and they might find something different.
Yeah, they may not go along with that agreement.
Okay,
You got that?
There's no real reason to believe
Ms.
that they
Johnson,
won't. Like you
Ms.
said.
Johnson, listen,
okay,
and I'm gonna make the ultimate determination, but would you want to talk with your attorney a little bit more just to make sure and be clear about what you're doing?
Yes, please. I would desire that.
Okay, all right. And Ms. Johnson, that's fair,
Okay,
right? Because I want to make sure I'm explaining it, but I want somebody that's on your side to also kind of go through it with,
okay.
kind of understand it.
You're doing a great job. I'm just a little slow.
I've done a
So-
great job.
You're doing a great job at
Yeah, say
explaining
that
it.
louder.
Okay,
No.
you're doing a great job.
Hey, thanks. All right.
Your Honor, may counsel briefly,
Nothing like fishing for compliments. Go
Okay.
ahead.
may counsel briefly approach?
You may.
Okay, thank you.
I'll be right back.
All righty.
Okay.
Yes, sir.
And then give you an opportunity to speak with your attorney. He'll probably speak with you certainly before that date, but then he'll speak with you on the date of that,
Okay.
okay? So that we can then make sure that you understand everything,
Okay, yes, sir.
okay?
Thank you.
And just so that you know, you're not in any trouble or anything like that
Okay.
for asking the question.
Thank you.
You know,
Appreciate that.
I have to make sure that you understand and I'll, you know, that everything's answered for you before you
Yes,
do.
sir.
All right?
You're doing a great job, Simpson.
Thank you. Thank you, Mr. All right.
All right.
I'll adjourn these
We'll
to
talk
the
to you.
20th.
Okay,
Take
yes, thank
care.
you.
Court does call the case, People versus Neil Hines. Yes. I do. Go ahead, Madam Prosecutor, if you can put your appearance on the record.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Thank you.
Thank you. Good morning, Your Honor. Assistant Public Defender Constable Bates on behalf of Neil Hines, who is present to my right. Can you state your full name for the record,
Good morning,
please,
Your
sir?
Honor, Neil Hines.
All right. I have before me a plea form that indicates that the defendant will be pleading to the charge of disorderly person. Is that a 90-day 100 or 90-day 500?
I believe it's 100, if I'm correct.
All right. I'll just do it that way. 90 days, 500 or $100 fine plus court costs. You understand that?
Yes, sir.
All right. And that the defendant then, after his guilty plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement. Is that correct, counsel?
Yes, Your Honor.
Yes, Your Honor.
All right. Thank you. May I have the defendant sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Neil Hines.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of disorderly person. That's a misdemeanor punishable by up to 90 days and or $100 fine plus court costs. You understand that?
Yes, sir.
Understanding that, you
Yes.
still wish to plead guilty?
Yes.
Well, I do also advise you that while I wouldn't be your sentencing judge, while I'm taking your plea, I wouldn't be your sentencing judge. You would be sentenced before Judge Ferry. Judge Ferry. Is anybody going to have an objection if I immediately sentence?
No, Your Honor.
No, Your Honor.
All right. So, sir, to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right. You had signed an advice of rights form.
Yes.
Any question regarding those rights?
No, sir.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, I'm not.
Has anybody promised you anything other than what's been stated here today on the record?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes, sir.
All right. We're gonna have to do this a little bit differently. On the date, it's gonna be a little bit difficult to do, but let's do it this way. During the course of the year 2024, right, sir? You failed to
Yes.
pay child
Yes,
support.
sir.
Is that correct?
Yes.
All right. While that has now been taken care of, you would agree that, well, you failed to pay child support. Right. All right. Counsel, I'll do it this way, just because it's a bit unusual. Without objection, I would accept his plea to the higher charge or I would accept his plea to the lower charge, having admitted the higher charge. Is there any objection to the court following that procedure?
No objection at this time, Your Honor.
No, Your Honor.
All right. Court will accept it. Has the court complied with the court rule in that regard, and would it be proper to accept this defendant's plea?
The defense is satisfied.
Yes, Your Honor, it's appropriate.
Thank you. Court will accept the defendant's guilty plea to count 2. Count 1 is dismissed. Sir, is there anything you want to say before I impose sentence?
No, I appreciate it, sir.
Fines and costs of $250. When can you pay that?
2 weeks.
2 weeks. All right. Pay it by March 31st, 2025. You'll have to pay it at the 15th District Court. Okay,
it online as
in
well.
downtown Ann Arbor.
Can I pay it online as well?
I'm not sure what their system is, but you probably can once they have it in there. All right, and I'll suspend 90 days in jail.
Thank you.
All right, thank you.
Thank you, Your Honor.
Court does call the case, People versus Johnny Bankhead Williams.
And on behalf of the people, Peter Heenan on behalf of the Bankhead Williams, who is the plaintiff.
You're requesting an adjournment.
Yes, Your Honor, I'm requesting a 2-week adjournment. I did ask for a lot of, I believe this is the case where I emailed for a lot of discovery in this case. And it's also my understanding that DNA is going to be necessary. I'm sorry, but you?
Different here.
Oh, no, Your Honor, I just emailed for discovery.
March 20th, 2025, 9 a.m. Bond will continue.
Your Honor, could you entertain client?
Pardon?
Would you be willing to entertain tethering for my client to his home address? No?
You're making a bond request?
Yes, Your Honor. You hit the thing really quickly. You went quick. You said everything really quick.
Well, make your argument.
Thank you. Your Honor, in this case, my client actually does not live in this area. He lives in the Detroit area. He has no desire to be anywhere near the address where this incident occurred. He can be tethered to the Detroit home, ensuring that the complaining witness will not have any experiences with him during that time frame, and he's asking for that opportunity.
Your Honor, people be opposed to any modification of bond. In this case, the defendant had been trespassed with the victim's residence and returned and tried to break into the residence. He broke her storm door trying to get in and only stopped when he saw police. He was found with a knife in his pocket and the residence and hiding under their bed scared. He also has a previous history of a conviction for felony firearms and an armed robbery in 2017. I had great concern for her safety, given that he had already been trespassed from that residence and went back to that residence.
Anything else?
Your Honor, he could have, they were having contact with her consent. So when he did go back, he had something at the house. He just wanted it back because he had been there previously, Your Honor.
Motion for bond reduction denied. Bond will.
Thank you.
Court calls the case, People versus Marquise Babb.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender, on behalf of Mr. Babb. Mr. Babb, could you state your name for the record once you reach the podium?
Your name?
Oh, Marquise Babb, how you doing today?
Doing great. How you doing? All right.
Judge, you're requesting an adjournment in this matter.
Probable cause conference will be adjourned March 20th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Thank you, sir. Yeah, you do. It sounds like I knew you were greedy. Court calls the case, People versus Michael Campbell.
Good morning, Your Honor. Victoria Burton here. Prosecutor appearing on behalf of the people.
All right.
Good morning, Your Honor. Assistant Public Defender Carson Baldesi on behalf of Mr. Michael Campbell, who is present to my right. Michael, can you state your full name for the record, please?
Michael Campbell.
You're requesting an adjournment?
No, Your Honor. We are now waiving the exam. I have a new form for you.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were you committed them?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all 4 counts.
Your Honor, may I address bond briefly?
Yeah, go ahead.
Your Honor, my client is going to be
You want to
requesting.
do the circuit court arraignment or you want to address?
Oh, I'm sorry. Yes, we could do the
Yeah, I
circuit
know.
court.
You didn't follow the rules. Go ahead.
At this time, we'd waive formal readings and stand mute to the charges.
Defendant in way formal reading standing mute. Court will enter a not guilty plea as to all counts. Pretrial will be set for
March 19th at 1:30 p.m. with Judge Conlon.
March 19, 2025, 1:30 before Judge Conlon. As to bond.
Yes, Your Honor, my client is requesting a PR bond while he awaits his circuit court pretrial. He's a lifelong resident of Ypsilanti. He has an 8-year-old son that he provides. He has a job at E.B. Brown awaiting for him. As to the allegations in the police report, there were no, but my client didn't threaten anybody. There was no violent actions on his behalf. So we would just ask for a PR bond in this matter, Your Honor.
Response from the people.
Your Honor, the fact that he was at an apartment complex, drunk, waving a gun around or having a gun in his possession, to me suggests that he was absolutely posing as a threat. Being drunk with a firearm in the middle of an apartment complex with the gun history and drug history that he has, I would ask that the bond stay exactly as it is, because I think it's appropriate both for community safety purposes and so that we can ensure he will remain with us and allow us to continue this prosecution successfully.
Anything else?
Yeah, Your Honor, I would just say that the alleged firearm was already seized. My client's already been in jail for 10 days now.
Motion for bond reduction is denied. Bond will continue. Thank you. Court calls case People versus Cameroon Brown.
The people. Assistant Public Defender Constable Liaison on behalf of Mr. Brown. Will you state your photo for the record, please, John?
Brown. Thank you.
Your Honor, requesting an adjournment at this time. There are still negotiations going on.
Probable cause conference will be adjourned March 20th, 2025, 9 a.m. Bond continues. Court does call the case of the People versus Mario Crawford.
Morning, Your Honor. Brian Bowling on behalf of Mr. Crawford. State your name. Judge, we have a resolution that's memorialized on a plea form before this court, and Mr. Crawford would like to take advantage of that today and plead no contest pursuant to that agreement.
And in this other case, is that taken care of on this or not?
Are you talking about, well, all the felonies are being resolved as part of that
So
plea.
Case 1459 will be dismissed
That's correct.
in its entirety.
Yeah, and he's pleading to 2 counts of attempted assault, resist, obstruct a police officer under the 55, or he's pleading no contest to fit under 5551, Judge, for lack of memory.
The plea form indicates that the defendant would be pleading to added counts 3 and 4, attempted resisting and obstructing the 1-year offenses. Upon a successful plea of no contest to that charge, counts 1 and 2 in case 5551 would be dismissed, as well as 22F2 1459 would be dismissed. That's the court's full understanding. Is that correct, counsel?
Yes, Your Honor. That is correct, Judge.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
All right, no comfort.
Sir, it is this court's understanding that you're going to be pleading no contest to 2 charges of attempted resisting and obstructing a police officer. Those are misdemeanors punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. You also do you understand what a no contest plea is, sir?
Yes, sir.
All right. 2 things about it. I have to make sure that you understand it. First means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
I also have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th.
Yes, sir.
Understanding all of that, you still wish to plead no contest?
Yes, sir.
To the charge of attempted resisting and obstructing a police officer contained in count 3, how do you plead?
No contest.
To that same charge as contained in count 4, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
All right. You signed an advice of rights form?
Yes, sir.
Any questions regarding those rights?
No, sir.
Look at paragraph 5. See one on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that.
Correct, sir.
You understand you're giving up the right to appeal of rights.
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody promise you anything other than what's been stated here today on the record?
No, sir.
Anybody threaten you or coerce you?
No, sir.
Doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
All right, the court has been provided and has reviewed Ann Arbor Police Department report for their case number 22-312. Any objections to the court having reviewed that report?
None for the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's pleas?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's pleas of no contest. 2 counts 3 and 4, counts 1 and 2, as well as case ending in 1459 are dismissed pursuant to that plea agreement. Pre-sentence investigation and report is ordered at 15th District Court. Probation sentencing in this matter will be March 28th, 2025, 10 a.m. before Judge Bond will continue.
Thank you, Judge.
Thank you. Court calls the case of the People versus Sheldon Brummett.
Good morning, Your Honor. Chief Assistant Prosecutor Victoria Burton Harris appearing on behalf of the people.
Brian Bowling on behalf of Mr. Brummett. State your name for the record.
Sheldon Brummett.
You're requesting an adjournment.
Yes, please, Your Honor. He's close to having the funds together, hiring an attorney. Right? Just
Well, didn't we adjourn it for that purpose already?
we did.
I told you at that time, I'm not adjourning it for that purpose again. We need to go forward on this case.
So just find it over because I thought I was getting out of jail and I stayed in jail longer, so I couldn't.
So you want to wait the exam, or do you want to set the exam? Will you pass the case, Judge? Let me speak to him. Thank you, Judge.
Court calls case of the people versus Van Davis.
Told you back.
I know, you told me you'd be back. Yeah. Welcome back.
Hey, well, nice to be here.
Assistant Public Defender Asif Bashir here with and on behalf of Man Davis. Mr. Davis, you can.
Man Davis here once again.
Yes, I know.
It's always nice seeing you.
Well, and you, Mr.
Thank
Davis.
you.
All right.
To our knowledge, discovery is complete. We would like to request the earliest possible preliminary exam date.
Preliminary examination, and would the people have their witnesses available the 18th?
Yes, Your Honor.
Preliminary examination in person, March 18th, 2025. Before Judge Moore. Bond will continue.
Thank you, Your Honor.
Davis, take care. You're not coming back anytime soon, are you?
I'm thinking about it.
All right.
I'll let you know.
Okay. Court calls the case, people versus Kevin Burton.
Ashalani for the people.
Your Honor, Alexis my Assistant Public Defender with and on behalf of Mr. Burden. Mr. Burden, could you state your full name?
Kevin Burton, Your Honor.
Thank you.
And Your Honor, we are requesting a brief adjournment here. I would ask for 2 weeks.
March 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Stephanie Cannon on behalf of Mr. Douglas, who is seated to my right. Mr. Douglas, could you please state your name for the record?
Clinton Douglas Jr.
Thank you.
Your Honor, my client is asking for his preliminary exam.
Is discovery complete?
Yes, Your Honor.
People have their witnesses available the 18th?
We'll do our best, Your Honor.
Your Honor, if I could address Baran.
Briefly.
Thank you, Your Honor. My client is, as you can see, he's in a wheelchair. He has little to no use of it. Is it your right knee or left knee? His right knee, Your Honor. Right now, they have him in max security because they can't put him on any other floor, I'm being told by my client at least, because he cannot navigate the stairs whatsoever. I understand that my client did not appear for court, Your Honor. In that case, the mailing address was his daughter's, and she told him the day after. My client didn't learn about it till the day after, but he wanted me to let the court know he just had a series of medical appointments because, again, his leg is not usable. And so he was just trying to get all of that taken care of. He has assured me, and I let him know, and he has to understand that when the court says he has to be here, he has to be here regardless of what's going on with his legs. Your Honor, he's just asking if you would be inclined to either tether him to the house and just allow him to do his medical appointments, but he'll be back when the court requires him to be back. Thank you, Your Honor.
I don't need a response. He knew he had to be here. There's been he's been told at various proceedings to be here. And he didn't appear, so I don't understand what the mailing issue is. He was given the date, and certainly he's had counsel who would have also provided the date to him. So that's not a justification for it. I'll set preliminary examination, March 18, 2025, 9 a.m. before Judge Barr.
I'm sorry, Your Honor, what was that date again?
March 18th.
3/18. Thank you, Your Honor.
Before Judge Barr. Motion for bond reductions denied. Bond will continue. Court calls case People versus Nathan Burns.
And there's a parent on behalf of people.
And Assistant Public Defender.
Your Honor, Ashalani for the people. I apologize, Your Honor. Could we pass this for one moment, please?
Yes, I'll pass it. Court calls the case of People versus Portia Elledge.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Portia Elledge. Ms. Elledge, please state your name.
Portia Elledge.
What are we doing?
Your Honor, Ms. Elledge would waive her right to a preliminary examination.
Is that correct?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes.
People also waive their right
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on both counts.
We acknowledge receipt of the information, waive a formal reading and stand mute.
Defendant every way former reading standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
March 20th at 1:30 before Judge Slay.
March 20th, 2025, 1:30, Judge Slay. Bond will continue.
Thank you, Your Honor.
Court calls case people versus Brandon Carter. Court calls case people versus Elton Ford.
Ashley Lonnie for the people.
All
Never mind, we can sit over here.
right. Your name, sir?
Alton Ford.
Yes.
I chose 11:18.
Well, where is he? Is he in Zoom? Sir, have you hired Mr. Dox?
Yeah, I did, but I don't know what's going on.
Me either. Because he appeared at your arraignment,
Right?
right? And then I don't know what happened. I didn't get some bizarre substitution of attorney, but the PD was never on the case. And Ms. Yagi signed it, but really shouldn't have signed it because I didn't accept it and I did not sign off on a substitution. We then told him that he needed, because you were in custody, he needed to be here and that he needed to file an appearance, which would be the proper way to do it. And he's not here. He wanted to appear via Zoom. I did not approve that because you were in custody and I felt you probably wanted to talk to him. That was my feeling.
And Your Honor, for the record, I have not had any direct communication from Mr. Dox regarding this case.
So, sir, so that you have representation at this point, the PD will represent you initially, okay? Because I'm not sure what's going on myself, so I just want to make sure that somebody's talking to you about what the case is about. Fair enough?
That's fair.
All right. So I don't know what I'm gonna do with this appearance. I'll tell you what. You can tell Mr. Dox, the court is not accepting his appearance. And that when he decides that he wants to bring himself to the court and talk to his client, the court will accept his appearance. This is a public defender case. Thank you, Mr. Brown.
Thank you, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Ford. Your Honor, today is the date and time set for the probable cause conference. We have not reviewed the discovery. We'd ask for a 2-week adjournment to be allowed to do.
Probable cause in this case will be adjourned March 20th, 2025, 9 a.m. His bond at this time will continue. All right. Thank you, Mr. Ford. Court calls case People versus Sean Cotton.
Morning, I'm Raymond Cook for the people.
This is Public Defender Chelsea Vergils on behalf of Sean Cotton. Your Honor, I received an email early this morning from Mr. Cotton, who informed me that he is at the Henry Ford Hospital in Detroit. I believe he had to have an emergency surgery. I would ask for an adjournment in this case. I do have intake paperwork that he signed today for Henry Ford.
You have paperwork from Henry Ford?
Yes, can I?
Oh, grant the adjournment request. Court calls case People versus John Fulton.
Good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Fulton, who's standing to my right.
Hello. Hello, your name?
John Fulton.
Thank you.
Your Honor, I would be asking for a 1-month adjournment. I did make a referral to our AIM division, and I think it's really important there's some social work intervention. I think that's going to be crucial to.
He was here yesterday, but I'm not sure what date we adjourned this.
Well, let me see. Yesterday you adjourned, you had me on from out of Pittsfield Township for. No, go ahead.
No, that's okay. I don't mean to interrupt.
For a traffic ticket.
That's right.
Right.
And I think it was adjourned, Your Honor, to the March 19th.
Okay, but this is obviously a more pressing issue, so.
Sorry.
All right. You wanted a month out?
I think that's what, I actually asked social work this morning if they thought a month was a good time frame. I haven't heard back, but I think it's probably safe to assume that
They're gonna take as long as they possibly can. They understand no urgency in it. No, I'm kidding. You can let them know I said that. Probable cause conference will be adjourned to April 3rd.
Thank you, Your Honor.
2025 at time. Bond in this matter will continue.
Okay, thank you.
Court calls case versus Stephen Crawford.
Stephen Crawford. Right here. No, I know you are. Assistant Public Defender Jay Bellinger on behalf of Mr. Crawford, who stands to my right. Mr. Crawford, can you please state your name for the record?
Stephen Crawford. All right, I have a plea form that indicates that the defendant will be pleading guilty to 2 charges: attempted resisting and obstructing a police officer's account 4, the 1-year offense, and account 5, operating while visibly impaired, the 93-day offense. Upon a successful guilty plea to those charges, counts 1, 2, and 3 would be dismissed. That's the court's full understanding. Is that correct, counsel?
That is correct, Your Honor.
May I have it sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Stephen Crawford. All right, Mr. Crawford, is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges? Is that correct?
Yes, sir.
All right, the first charge is that of attempted resisting and obstructing. That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, sir.
The second charge is that of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail and $300 fine plus court costs. The court could order any community service or rehabilitative services the court deems necessary. Court could also order your vehicle immobilized, could order your vehicle forfeited, could also order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, sir.
All right. Understanding all of that, well, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Moore in the 15th District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, I did.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5, and you'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yep.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
November 14th, 2024, at the location of 380 Parkland Plaza, Ann Arbor, Michigan, Scioto Township, Washtenaw County, Ann Arbor, Scioto Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
What'd you have and how much?
I had a couple shots of whiskey.
All right. Were you stopped by the police?
Yes, sir.
What do you mean, yeah? Were you stopped by the police or was there an accident?
I put the car in the ditch.
Oh, so that's an accident unless you did that on purpose.
Right.
Right? Accident. Police did arrive?
Yes, sir.
All right. Were you ultimately arrested?
Yes, sir.
Were you taken to the hospital or the police station?
Both.
All right. At the hospital, was there a blood draw?
Yes, sir.
What were the results of that blood draw?
Your Honor, I believe that there was a combination. I believe the official results,
It was a 0.04 alcohol, but then 45 nanograms per milliliter of cocaine and some quantity of benzos as well.
All right.
stipulate to that, Your Honor.
Okay. You have no reason to dispute those results, do you, sir?
No.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol and ingestion of those?
Yes, sir.
drugs? All right. When you came into contact with the police, what happened that makes you think that you're guilty of the offense of attempted resisting?
When I was detained, they put me to the ground and I got put to the ground. My foot hit them in the face. So, yeah.
Okay, so they were just putting you on the ground.
Well,
What do you do?
I was resisting.
In what way were you resisting?
I was holding my arms back and I wouldn't let them put my arms behind my back.
Because they were trying to cuff you.
Yes.
And you were resisting being cuffed.
Yes.
And that's why you went to the ground.
Yes, sir.
Yeah, okay.
Defense is satisfied, Your Honor.
Court will accept the defendant's pleas. Guilty to counts 4 and 5. Counts 1, 2, and 3 are dismissed. I don't know why people do that. It doesn't work out well. Doesn't work. Pre-sentence investigation as well as screening and assessment is ordered at 15th District Court. Sentencing in this matter will be
March 14th at 9 a.m. before Judge Moore.
March 14th, 2025, 9 a.m. before Judge Moore. Bond with its conditions will continue.
শাড়ি শাড়ি কেন?
আমি কি তোরে কিছু দিতে পারি না?
এমনি করে টাকা খরচ করলে টাকা জমাইবা কেমনে?
দূর, একটা শাড়ির আর কতই দাম।
শাড়িটা কিন্তু সুন্দর আছে।
আচ্ছা একটু পরে দেখা না।
আরেকদিন পরবো।
কি কস? পর না, তোরা অনেকদিন শাড়িতে দেখি না। রাবেয়া, রাবেয়া,
খুলতেছি।
ঘুমাইছো?
অনেকক্ষণ আগেই ঘুমাইছে।
বাজার
মা, এত বাজার কেন আনছো?
না, এত বাজার কই? ঘরে একটা নতুন মানুষ আসতেছে না, ওর জন্য খাওয়ান দরকার আছে না?
রাক্ষসের মতো খাইবো তো সবাই, এত বাজার করে লইছো।
আরে না, রাক্ষসের কিছু নেই। যাও বাজারটা রাখো। আমি চিন্তা করছি কি, ধার কর্জ করে হইলেও টাকা পয়সা জমায়া একটা সেকেন্ড হ্যান্ড মোটরসাইকেল কিনবো।
মোটরসাইকেল কেন?
আরে ভাড়ায় গাড়ি চালায় খুব একটা লাভ হয় না, এদিকে তেলের দাম বাড়তি, তারপরে যে চাকরিটা করি সেখানে তো টাকা পয়সা খুব বেশি দেয় না। ঘরে একটা নতুন মানুষ এসেছে, আমি যদি এই চাকরিটা ছাইরা যদি বাইক রাইড সারাদিন করি তখন কিছু টাকা আসবো, ভালো হইব না?
দেখো যত যাই কও, চাকরির কিন্তু একটা নিশ্চিত ইনকাম আছে, সেটা কমই হোক। চাকরিটা ছেড়ে দিয়ে কি ঠিক হইব?
তাও ঠিক, কিন্তু এই যে ঘরে একটা নতুন মানুষ এসেছে, একটু নতুন করে চিন্তা করতে হবে না, টাকা পয়সা লাগবে তো।
জানি না, সেটা করো ভাইবে চিন্তা কইরো।
আচ্ছা তুমি অত চিন্তা করো না, এটা তো এখনই কিনতেছি না, টাকা জমাতে তো একটা সময় লাগবে, তাও ধরো 6-7 মাস তো লাগবেই। তারপরে রফিকরে কইছি যে যখন মোটরসাইকেল কিনবো তখন কিছু টাকা ধার দিতে, ও রাজি হয়েছে, মিলাঝুলা একটা কিছু হইব। আচ্ছা বাদ দাও, এই
শাড়ি শাড়ি কেন?
আমি কি তোরে কিছু দিতে পারি না?
এমনি করে টাকা খরচ করলে টাকা জমাইবা কেমনে?
দূর, একটা শাড়ির আর কতই দাম।
শাড়িটা কিন্তু সুন্দর আছে।
পছন্দ হয়েছে তো? আচ্ছা একটু পরে দেখা না।
আরেকদিন পরবো।
কি কস? পর না, তোরা অনেকদিন শাড়িতে দেখি না।
শরীরটা ভালো লাগতেছে না।
বেশি খারাপ লাগতেছে?
আরেকদিন পরে দেখা।
আচ্ছা ঠিক আছে, তাহলে খাবার দে। ও কি খাইছে? কি রে বাপ, আরে কি মশা রে।
Hey, good morning, Your Honor. Attorney Kevin Basant, P71061 on behalf of Mr. Tavay Mills. Mr. Mills, please state your name for the record.
Tavay Mills.
Thank you. And Judge, just for the record, Your Honor, I did substitute in on all three of these matters very recently, Judge. I would just ask I be assigned to each case, Your Honor.
Well, you're retained?
Retained counsel, just enough.
Do I have the orders?
Well,
okay. All right, you're in.
Thank you, Judge.
So you're requesting an adjournment?
I am, Judge. Today's date and time scheduled for PCC. I need discovery in all three cases, Judge, so we're asking for a new probable cause conference.
You want 2 or 3 weeks?
Judge, can we get 3 weeks, Your Honor?
Probable cause conference will be March 27th, 2025, 9 a.m. Bond continued.
May I very briefly address bond?
Briefly.
Yeah, just very briefly, Your Honor. My client, he's 20 years old, Your Honor. He did have a prior case, but that was under HIDA. He successfully completed that. Judge, I understand these are very serious charges. The bond is $250,000 cash surety. I would ask the court to consider at the very least, Your Honor, a 10% condition with a tether, Your Honor. His family is in court. He was working prior to being arrested in this particular case, Your Honor. He would have no contact with the law, and with the tether, he can be monitored and tracked, Your Honor. So we're just asking for a 10% provision with a tether.
Response from the people.
Your Honor, the defendant was charged in, I believe it's 25 F10203 with, among other things, possession with intent to deliver meth, felony firearm. The defendant was producing Glock switches using a 3D printer as well as ghost guns. When the police went to arrest him on that warrant last week, he attempted to flee, crashed into an MSP trooper, was involved in a chase with Pittsfield police. When they eventually apprehended him, he was again found in possession of a firearm. During that chase, they subsequently searched his home and found more with, I guess you would call molds in producing these ghost guns, as well as suspected controlled substances. So obviously, he's not only a danger to the community, but also a flight risk. I'd ask that bond remain as currently set.
Anything further, counsel?
Nothing from the defense counsel. Your Honor.
Motion for bond reduction is denied. The court does consider the defendant a danger to the community and certainly a flight risk also. Bonds will continue in each of these cases.
Thank you very much, Your Honor.
Court does call the cases of the people versus Samantha Warren.
Andrew Childers, appearing on the
Edward Dickerson, Samantha Warren.
Private First Class Samantha Warren.
Thank you.
Your Honor, there's some negotiations that are still going on. I'm asking for an adjournment in this case, in all 4 cases.
How much time did you need?
At least 2 weeks, whatever the court's preference is.
March 27, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court does call the cases of the people versus Jeffrey Stoops.
Alexander on behalf of the people.
And Edward Drugas on behalf of Jeffrey Stoops in the 1740 matter.
And good morning, Your Honor. Assistant Public Defender Shanase Carey Akinrui on behalf of Jeffrey Stoops on the 1740 matter.
Good morning. My name is Jeffrey Allen Stoops.
In the 1740 matter, I'm looking to obtain video in situation, so I'm asking for an adjournment.
And Your Honor, in my matter, we would be requesting an adjournment. We want to see if he would be eligible for a recovery court.
Probable cause conference in these matters, March 27, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case of the people versus Elizabeth Black.
Alexander on behalf of the people.
Good morning, Your Honor. For the record, Brendan Dubowski appearing on behalf of Elizabeth Black, who's standing at the podium to my right. Ms. Black, please state your name for the record.
Elizabeth Black.
Your Honor, today's date and time set for a probable cause conference. I was just retained on this matter this week. I filed this substitution of counsel yesterday. Spoke to the prosecutor today. We're just asking for an adjourned probable cause conference. I've explained to my client the 14-day rule, and she is voluntarily waiving that. Is that correct, ma'am?
Yes.
March 27, 2025, 9 a.m.
Your Honor, I'm going to be out of town that day. Is it unless it's possible I can do it via Zoom, but if not, can we have the 3rd? Is that available?
April 3rd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Eddie, can you please state your name for the record?
Eddie Garden.
Thank you. All right. What are we doing on this?
Judge, this is a date and time set for a PCC. At this time, we would be asking for a 3-week adjournment of the PCC to obtain all the necessary discovery.
In both cases?
Yes, Judge, that is my understanding. Is that your understanding, Mr. Childers?
Oh, he's got the new case and then.
The new case is we would be adjourning for discovery. The previous case is, yes.
And I think we will have a resolution, well, a